I thought I was paying my rent like clockwork until I found out my landlord had been pocketing every cent. What happened next was the sweetest revenge imaginable. I still remember that sweaty July afternoon when I first stepped into the old brick building on Elm Street. The peeling paint on the staircase and the faint smell of mildew in the hallway did nothing to dampen my excitement. At 26, I'd finally found a place within my budget, close to work, with just enough character to feel like home. My heart pounded as I unlocked the apartment door for the first time, imagining cozy movie nights on the threadbare couch and lazy Sunday mornings in that tiny kitchen. My landlord, Ms. Evelyn Green, was waiting with a clipboard and a crisp smile that almost seemed too polished for the dusty lobby. She rattled off lease terms faster than I could scribble signatures. 12-month contract, $1,200 due on the first of each month, no pets, and absolutely no subletting. I nodded along, eyes darting to the stained carpet and the sagging ceiling fan. But Ms. Green's enthusiasm was contagious. She handed me 2 shiny keys and wished me all the best, her sunlit expression promising that everything would be smooth sailing from day one. We agreed to handle my rent payments through an online portal linked to her bank account. Each month, I dutifully logged in around midnight on the due date, transferred $1,200, and watched as the balance dropped from my account. No envelopes to mail, no trips to the office, just a few clicks, and I was covered. For the first 3 months, I never gave it a second thought. The portal sent me confirmation emails, and Ms. Green's texts always read, "Payment received, thank you." I admired her efficiency, even shared a grateful emoji in response. Then came October. I transferred my rent on October 1st at precisely 11:57 p.m., double-checked the confirmation email, and collapsed into bed. But 2 days later, a different email arrived, this one from Ms. Green's property manager. It read, "Our records show no payment for October. Please remit $1,200 plus a $75 late fee immediately to avoid eviction proceedings." My chest hit my desk. How could this be? I scrolled through my inbox. The original confirmation was still there, time-stamped on October 1st at 11:58 p.m. I forwarded both emails to the property manager and waited, baffled. When I called Ms. Green, she sounded curt, her earlier warmth replaced by practiced professionalism. "According to my bank," she said, "I've received nothing. I suggest you speak with your bank tomorrow." That was it. No apology, no sympathy, just a brisk click as she hung up. My blood boiled. I glanced back at the portal. It still listed October's payment as completed, complete with a green checkmark and reference number. Something was very wrong. Determined to get to the bottom of it, I requested detailed bank statements for both my account and the portal's recipient account. The bank emailed me a PDF by nightfall. Scanning the PDF line by line, I saw the rent payments for July, August, and September, each $1,200, clear as day under Green Holdings LLC. But October's transaction was nowhere to be found. Instead, there was a mysterious deposit of $1,200 into an account held in the name E. Green Properties, routing number different from the one on the portal. My jaw dropped. Someone had rerouted my hard-earned rent. That night I lay awake, replaying every interaction. The polite smiles, the prompt texts, those soothing confirmation emails. Was it all an act? My landlord had crafted a perfect facade to lull me into complacency, while lining her personal pockets. I pictured her, perhaps sipping wine in some upscale restaurant, congratulating herself on fooling yet another tenant. Rage and adrenaline coursed through me. I couldn't let her get away with this. I swung my legs over the side of the bed, heart thundering. If she thought she could hijack my rent and dodge consequences, she hadn't met me. I grabbed my laptop, opened a blank document, and started jotting down everything. Dates, amounts, account numbers, the exact wording of her emails, even the timestamps on our text messages. This wasn't just about getting my money back anymore. It was about exposing her scheme and making sure she paid the price. Revenge, I decided, was the only rent she deserved. Update 1. The next morning, I woke to an uneasy calm, the kind that settles after a thunderstorm has passed overhead but before the air finally clears. My list of evidence lay sprawled across the bed. Printed bank statements, screenshots of confirmation emails, the lease agreement with Ms. Green's signature. I brewed a strong coffee and opened my laptop, determined to turn this paper trail into something she couldn't deny. First, I needed to confirm exactly who controlled which account. The portal's footer listed Green Holdings, LLC as the payee, but the routing number on that document didn't match the mysterious Green Properties routing number on the October deposit. I copied both sets of digits into a spreadsheet, highlighting the discrepancies in bright red. Next, I dug into public business records. A quick search on the state's Secretary of State website revealed two separate entities registered at the same mailing address: Green Holdings, LLC, established 2012, and Green Properties, incorporated 2019. The names were nearly identical, but their registered agents differed. Green Holdings listed Ms. Green's sister, while Green Properties listed Ms. Green herself. Evidently, she'd spun off a second shell company and quietly redirected payments there. My pulse quickened. This was solid proof of intentional fraud. I emailed the PDF of my findings to my friend Claire, a prosecutor in the county district attorney's office. I'd avoided telling her too much over text, Legal Ethics 101, but I knew she'd point me toward the right resources. Within an hour, her message pinged back. "This looks shady as hell. File a complaint with the DA's office under tenant fraud, and consider getting a lawyer before confronting her directly." It wasn't the note I wanted to write, but it was the smartest move. Rage had to be tempered with strategy. I needed a professional edge. While waiting for Claire's official guidance, I drafted a detailed timeline of events. I summarized every rent payment, the portal confirmations, the date I noticed the missing October deposit, and the bank's confusing statement. My fingers flew across the keys. Each word felt satisfying, like hammering nails into the coffin of Ms. Green's impropriety. I printed the timeline and added sticky tabs to critical lines: the October confirmation email, the routing number mismatch, the state business registration page. Soon, I had a thick dossier I could slide across any lawyer's desk and make them sit up straight. That afternoon, I scheduled a meeting with a tenant rights attorney named Marcus Chen. His office was a 15-minute walk from my apartment, in an aging but dignified brick building on Maple Avenue. When I arrived, I was surprised to see a modest plaque on the door: Marcus Chen, Esquire, fighting for fair housing. Marcus greeted me with a firm handshake and led me into his wood-paneled office. As I spilled out the story, each document I handed over, the look on his face shifted from polite interest to concern. "Your landlord set up 2 LLCs to intercept your rent," he said, flipping back and forth between my timeline and the state filings. "That's not just unethical, it's criminal. Felony-level theft. We can file for an injunction to freeze both accounts and file suit to recover triple damages under the state's landlord-tenant law." He ran through my options: file a civil suit, press criminal charges, and issue a public complaint to the Real Estate Licensing Board. Each path had its pros and cons. The civil case could net me damages but might drag on for years, whereas a criminal complaint could trigger a swift investigation but might not guarantee I get my money back. Marcus suggested a dual strategy: immediately send a cease and desist letter via certified mail demanding that all future rent be redirected to a court-controlled escrow account, while simultaneously alerting the DA's office to open a criminal probe. I walked out of his office energized, clutching a draft of the cease and desist letter. On the way home, I popped into the local copy shop, sent the letter via certified mail, and grabbed a sandwich from a deli down the street. With each step, I rehearsed how I would confront Ms. Green's crooked scheme. "Your diversion of rent payments stops now, or you'll answer to the full extent of the law." I felt a strange thrill at the thought of watching her scramble. Back in my apartment, I set up 2 email threads, one addressed to Ms. Green, the other to the county DA's office. In the DA's email, I attached my timeline, the business registration PDFs, and a copy of the certified mail receipt from the cease and desist letter. In the email to Ms. Green, I was cold and concise. "Ms. Green, effective immediately, all future rent payments for apartment 3B must be sent to the attached escrow account. Details enclosed. Failure to comply will result in formal legal action, including criminal charges for theft and civil claims for damages. Sincerely, your tenant." I hit send on both emails within seconds of each other, then leaned back and let out a breath I didn't realize I'd been holding. The die was cast. In less than 24 hours, Ms. Green would have to choose: comply quietly or fight a legal war on multiple fronts. As evening fell, I discovered an unexpected side effect of my crusade. Sympathizers started to emerge. A neighbor from down the hall, Alan, knocked on my door with his own horror story. M's. Green had raised his rent without notice, then threatened eviction when he questioned the charge. He handed me copies of his own late fee notices. Across the corridor, a young couple, fresh college grads, whispered that their security deposit had vanished into thin air. Word was spreading. Suddenly, my personal battle felt like part of a larger uprising. Maybe this scheme was her modus operandi, and I was the spark that would ignite a rebellion among all her tenants. I saved those stories in separate files. If the DA's office wanted a trend of tenant abuses, here it was, a growing list of grievances lining up behind me. I messaged Claire with the good news. I have at least 3 more potential witnesses. DA might take this up tomorrow. Her reply was swift and encouraging. Solid. Keep them organized. And text me if you get any pushback from her. I sat back, eyes flicking to the glowing inbox. Pushback was precisely what I was waiting for. My phone buzzed just after midnight. It was a short, scribbled text from Ms. Green. Your rent check for November bounced. Please explain. My smile in the dark was feral. I knew exactly what happened next. She would see the cease and desist. She would feel the DA breathing down her neck, and she would make the first move. And when she did, I'd be ready. With a camera rolling, a stack of lawyers on speed dial, and a dossier thick enough to bury her in subpoenas. Update 2. I didn't sleep much after Ms. Green's late-night text. Her accusation that my November payment had bounced felt like a mocking echo of her own scheme. By morning, I already knew how I would respond. First, I grabbed my phone and snapped a photo of the certified mail receipt for the cease and desist letter. Its bright green delivered sticker glowed like a victory banner. Then I drafted a calm but firm reply. Ms. Green, please refer to the cease and desist letter delivered yesterday via certified mail. All rent payments must now be directed to the court-controlled escrow account. Any payments sent to your personal accounts will not be accepted and may constitute further theft. Thank you for your prompt attention to this matter. Your tenant. I hit send and leaned back, steeling myself for her inevitable tantrum. Within 30 minutes her response came, an angry paragraph accusing me of harassment and threatening legal action against me for disruption of property management. She ended with a veiled warning. I advise you to reconsider your unfounded accusations, or you will face consequences. Her email dripped with indignation, but I felt surprisingly calm. I forwarded it to Marcus Chen with a single line, counter threat from her. Advice? Marcus replied within the hour. This is exactly what we expected. Intimidation. Do not engage further in email. Instead, document her threats and share them with the DA. I'll file for the injunction today to freeze her accounts. Bolstered by his support, I logged into the DA's victim portal and uploaded the cease and desist letter, my correspondence with Ms. Green, and now her retaliatory threat. I also attached screenshots of her harassment email. Its shady language would help establish a pattern of bad faith tactics. Clicking submit, I felt a measure of relief. The wheels of justice were in motion. That afternoon, I checked my email to discover a notice from the court clerk. My request for an injunction hearing was scheduled for November 12th, just 10 days away. The court would review my evidence and, if satisfied, order all future rent payments placed into escrow under the court's supervision. From that point on, Ms. Green would have no access to the funds. I printed the scheduling notice and taped it above my desk, a tangible milestone on my path to vindication. Encouraged by my progress, I reached out to Alan, the neighbor from down the hall, and the young couple whose deposits had vanished. We convened in the building's dimly lit laundry room, a neutral territory where Ms. Green's surveillance cameras were fewer. I spread out my documents, the cease and desist letter, the injunction notice, and a growing stack of complaints from other tenants. Alan nodded, eyes fierce. What can I do? He asked. Together, we drafted sworn affidavits, personal statements recounting Ms. Green's late fees, threats, and rerouted payments. Each affidavit was notarized at a local kiosk, then scanned into PDF form. Before leaving, the young couple whispered their gratitude. If you hadn't stood up, we'd still be terrified. Their words warmed me. This wasn't just my fight anymore. But Ms. Green was not the type to back down. 2 days later, I found a slip of paper under my door, a single sentence scrawled in hurried handwriting. "Pay me or get out. Your lease is void." No signature, no official letterhead, just a threat. My stomach tightened. She was testing boundaries, trying to frighten me into silence. I photographed the note and added it to my evidence folder. Then I called Claire, the DA prosecutor, and explained the development. She assured me the harassment note would strengthen the criminal case, making it clear that Ms. Green was engaging in ongoing intimidation. "Keep everything documented," Claire urged, "and stay safe." With the injunction hearing looming, I decided to go on the offensive publicly. I created an anonymous Facebook group for Elm Street Tenants United and invited residents to join. Within hours, 10 people had signed up, posting horror stories of unpaid deposits, illegal rent hikes, and unexplained fees. I linked to court records, showing the injunction request, and shared redacted copies of our affidavits. The group buzzed with outrage, and comments flooded in. Neighbors offering legal referrals, activists pledging to spread the word, even a local reporter asking to interview us for a community news segment. I felt a thrill. This was bigger than just me. Ms. Green's web of deception was unraveling in public view, but not everyone in the building agreed to speak out. Some tenants, fearful of eviction or worse retribution, stayed silent. I respected their choice but worried about collateral damage. So I wrote an email to Ms. Green, this time CCing the local housing authority and a housing rights nonprofit. Ms. Green, several of your tenants have raised serious concerns about irregular rent payments, unauthorized fees, and harassment. A civil injunction hearing is scheduled for November 12th, and a criminal investigation is underway. Additionally, tenants have registered complaints with the housing authority. To avoid further legal escalation and potential license revocation, you may comply with the court's escrow order and cease all improper practices. Regards, the tenants of Elm Street building. I paused before sending, fingers hovering over the send button, conscious of how provocative it was. But I clicked anyway. Within minutes, I received a reply, not from Ms. Green, but from a representative of the housing authority. They thanked me for the detailed complaint and said investigators would visit the property later that week. I allowed myself a small smile. The pressure was mounting from every side. That night, as I sat at my desk organizing digital copies of invoices and affidavits, I realized how far I'd come in just under 2 weeks. What began as a simple rent payment had turned into a full-scale campaign. Legal battles, tenant solidarity, public outcry, and government scrutiny. I felt the dark thrill of control, no longer the powerless tenant, but the architect of her downfall. And yet, a sliver of doubt gnawed at me. Was I ready for what came next? The injunction might pass, but the court could deny it or delay the hearing. Ms. Green could retaliate further, perhaps by filing her own suit or stirring up local politicians. But I reminded myself of Marcus's words, "Fight smart, gather allies, and don't back off." So I saved my work, powered down my laptop, and stood by my window, gazing at the streetlights glowing like watchful eyes. This was only the midway point in our battle, and I was more determined than ever to see it through. Update 3. The morning of November 12th arrived with a brittle chill in the air. I dressed in a navy blazer and crisp white shirt, my court uniform, I joked to myself, clutching a folder packed with every shred of evidence we'd amassed. Bank statements, LLC filings, affidavits from neighbors, the cease and desist letter, and Ms. Green's own threatening emails. Marcus met me outside the courthouse steps, his calm confidence a balm for my jittery nerves. "No matter what happens in there," he said, "we've already won the court of public opinion. Today's about locking down the legal remedy." Inside the packed courtroom, the air felt thick with anticipation. Dozens of tenants filed in behind me, faces familiar and new, wearing winter coats and hopeful expressions. A local housing rights advocate held a sign reading "Fair Rent for All," and a few reporters from the community news outlet hovered with notepads. The judge, a middle-aged woman with steely eyes and an impeccable bun, called the hearing to order and asked us to approach the bench. Marcus began by succinctly stating the case. "Your Honor, my client has been the victim of a deliberate scheme by his landlord, Ms. Evelyn Green, to siphon rent payments into a shell account. We seek a preliminary injunction to redirect all future payments into escrow, pending the outcome of both civil and criminal proceedings. He laid out the evidence methodically. Payment confirmations for July through September, the mismatched routing numbers for October and November, the state registration filings highlighting two separate entities, and the sworn affidavits detailing harassment and threats. When it was Ms. Green's turn, her attorney, a slick, sharp-suited specialist in landlord-tenant disputes, rose and launched into a rapid-fire rebuttal. He argued that E. Green Properties was a legitimate corporate affiliate, that any discrepancy in routing numbers was a clerical error, and that my client had, quote, disrupted property management with baseless allegations. He produced a single invoice showing that the escrow account Marcus had proposed bore a handwritten correction, an apparent oversight, he claimed. He also attempted to cast doubt on the affidavits, questioning the neighbors' motives and suggesting they'd been coached by advocacy groups. My heart thumped as I watched the judge pore over the exhibits. Marcus objected firmly to the attorney's insinuation of witness coaching, pointing to the notarization stamps and the diversity of statements. Then, to undercut the clerical error defense, he presented a certified copy of a bank letter showing that the routing number for Green Holdings, LLC, had never changed since 2012, whereas E. Green Properties' routing number was deliberately registered in 2019. The judge marked it as Exhibit 12 and raised an eyebrow. After an hour of pointed exchanges, the judge recessed for her ruling. During the break, I felt a swell of nerves. What if she sided with Ms. Green's attorney? But the hushed murmurs among tenants and the encouraging thumbs up from Claire, who'd slipped in for moral support, steadied me. I took a deep breath, reminding myself that we'd done our homework. When court reconvened, the judge cleared her throat. Having reviewed the motions and exhibits, I find that there is a substantial likelihood of success on the merits of the plaintiff's claim that the defendant diverted rent payments improperly, she announced. I will grant a preliminary injunction ordering that all future rent payments for Apartment 3B be placed into the court's escrow account until further order. The defendant is enjoined from accessing the prior diverted funds pending resolution of this matter. She set a hearing date for the broader civil trial in January and adjourned the proceedings. A ripple of applause broke out among the tenants. I let out a breath I didn't realize I'd been holding, feeling both relief and vindication. As Marcus patted me on the back, the housing advocate handed me a folded news article about the case, front-page coverage in the local community paper. Photographers snapped a few triumphant shots of me standing alongside neighbors, raising fists in solidarity. For a moment, it felt like the climax of a movie. But the elation was tempered by a sobering reality. Ms. Green had already messaged us through her attorney demanding immediate vacating of the escrow directive and threatening an appeal. That evening, I sat at my desk reviewing the judge's order and drafting responses to counsel. Claire reminded me that the criminal investigation was still ongoing and that stronger charges could follow if the DA found evidence of wire fraud. I forwarded the injunction order to the DA's portal and flagged the appeal threat as further intimidation. Over the next few days, the building's atmosphere shifted. Tenants whispered more openly, some reviving hopes of recovering security deposits. Alan reported that his landlord had quietly stopped sending late fee notices. The young couple found a lawyer to recover their missing deposit. Ms. Green, meanwhile, had posted a cryptic notice on the lobby bulletin board, warning tenants to respect the landlord's rights and reminding us all of lease obligations. I photographed it for the record and added it to our harassment folder. As November turned to December, I spent evenings drafting questions for depositions, coordinating with other tenants, and preparing for the upcoming trial. Every document filed, every witness statement notarized, felt like another brick in the wall we were building around her misconduct. The war had shifted from an isolated conflict over diverted rent to a full-scale legal siege. Yet under the court victory lay a quieter tension. I struggled to sleep, haunted by the possibility that Ms. Green's appeal could delay the injunction, or that she might retaliate personally once the cameras and tenants weren't watching. When doubt crept in, I reminded myself of Marcus's advice. Stay vigilant, document everything, and use the law to protect yourself. With the injunction in place, she could no longer siphon rent, but the larger battle for damages and criminal accountability was just beginning. That realization sent a fresh charge of determination through me. I poured another cup of coffee, opened my laptop, and started outlining our strategy for the civil trial, drafting witness lists, mapping out chronologies, and coordinating with Claire on criminal follow-ups. The courtroom showdown was won, but the war was far from over. Update 4. With the preliminary injunction secured, December settled in like a frost that refuses to melt. The court's escrow order meant Ms. Green could no longer touch our rent, but her tactics only became more brazen. One evening, I returned home to find the lobby walls plastered with photocopied legal notices threatening tenants with eviction, unless they signed an addendum acknowledging full and final satisfaction of all past due amounts. Ironically, all of which had been rerouted into her shell company. Beneath the typed text, someone, almost certainly Ms. Green, had scrawled in red ink, "Sign by Friday, or you're out." I photographed the notices and posted them to our Elm Street Tenants United group, alongside a translation explaining that the addendum was a void document designed to confuse tenants into forfeiting their rights. Comments exploded. Neighbors shared concerns about whether signing might actually constitute an admission of guilt. I spent the next 2 hours drafting a clear, step-by-step guide explaining why no one should sign anything without legal counsel and how to submit questions to Marcus or the housing authority. As snow began to fall outside, I felt the warmth of solidarity. Residents were no longer isolated victims, but a united front. Meanwhile, Marcus Chen had begun depositions for Ms. Green's appeal. I sat through 2 mornings of giving sworn testimony in his modest conference room, answering questions about how I discovered the diverted payments, how I organized other tenants, and my interactions with the DA. Sitting under oath, each detail I'd meticulously documented became a weapon. Claire accompanied me to one session, taking notes and coaching me on how to handle Ms. Green's attorney's traps. By the time we finished, I felt drained but confident. There was no wiggle room left for Ms. Green's defense. But the real breakthrough came when a local investigative blogger, Mary Ann Watts, reached out. Mary Ann had spotted our Facebook group and the community paper's front-page story and asked for an interview. I agreed, sending her sanitized copies of the court order, the shell company filings, and the eviction addendum notice. 2 days later, her exposé went live, a detailed multimedia piece on Elm Street's Landlord from Hell, complete with embedded photos, scanned documents, and first-person accounts from me, Alan, the young couple, and 3 other tenants. The headline blared, "Inside the Rent-to-Own Racketeer's Empire, How One Landlord Duped Dozens." Views surged into the tens of thousands within 24 hours. Social media lit up. Concerned neighbors, tenant rights groups, and even a handful of city council members began sharing Mary Ann's article. A petition calling on the city's housing commission to revoke Ms. Green's rental license crossed 2,000 signatures overnight. Suddenly, this wasn't just a legal battle, it was a social movement. Empowered by the groundswell, I coordinated with Mary Ann to host a livestream Q&A for tenants across the city, not just Elm Street. We advertised it via the Facebook group and local community boards. On the night of the stream, over 300 people tuned in. Renters from other buildings shared stories eerily similar to ours. People asked how to check their landlord's corporate filings, how to spot routing number discrepancies, and how to organize safely. I answered alongside Marcus and a representative from the housing authority. By the end, dozens of viewers pledged to file formal complaints in their own jurisdictions, and tenant organizing groups promised to send observers to our upcoming civil trial in January. As the publicity storm grew, Ms. Green's options narrowed. Her attorney attempted once more to stay our injunction, citing, quote, "financial hardship and procedural irregularities," but the motion was denied, this time without even a hearing, when the judge noted her pattern of creating LLCs solely to siphon funds. The refusal, published in the court docket and picked up by local legal blogs, was another public defeat for her. Yet Ms. Green was nothing if not resilient in her nastiness. On New Year's Eve, I received an email from her attorney suggesting a, quote, "settlement conference to discuss amicable resolution of the dispute." The tone was syrupy but patent in its ploy. By dangling a settlement, they hoped to pressure me into dropping the criminal complaint or scuttling the civil damages claim. I forwarded the offer to Marcus, who advised caution. This is a tactic to derail your momentum. If you settle now, you forfeit claims for treble damages, and the full criminal investigation could fizzle out. He recommended declining and instead pushing forward with the trial. Behind the scenes, Claire confirmed that the DA had drafted an indictment for wire fraud and embezzlement against Ms. Green, targeting the 12 diverted rent payments over the past year. The grand jury was expected to convene in February. At the same time, our civil trial was set for a mid-January start date. The calendar pages blurred together as I balanced final trial preparations, drafting opening statements, lining up witnesses, and coordinating with Marianne to ensure media coverage of the trial's opening day. On the afternoon before trial, I walked the building halls with a fresh round of flyers. Civil trial, Elm Street tenants versus rent-to-own racketeer. I tapped on doors, urging tenants to attend the January 14th hearing in courtroom 5B. Many nodded and took flyers. A few even offered to testify. As I returned to my apartment, I felt the weight of what we'd accomplished and the enormity of what still lay ahead. The trial could grant us financial restitution, but the criminal process could finally strip Ms. Green of her license and send her to jail. That night, I found myself unable to sleep, images of her eviction addendum notices flashing behind my eyes. Yet beneath the anxiety lay a current of fierce determination. I opened my laptop and composed what would become my opening statement for the civil trial, a clear-eyed narrative of deception, abuse of power, and the collective courage of tenants who refused to be silenced. Every word I typed echoed the fight not just for my own money, but for every renter who'd ever been exploited. With that drafted, I finally closed the laptop, heart-pounding but resolute. The world was watching now, and no amount of intimidation could undo that. The next morning, I would stand before the judge, the DA, Ms. Green's legal team, and a courtroom full of supporters, and tell the unvarnished truth. The battle had escalated from a personal vendetta to a public crusade, and I was ready for whatever came next. Update 5. The gray light of mid-January morning filtered through the courthouse windows as I arrived in courtroom 5B for the civil trial's opening day. Clad again in my navy blazer, I felt a mixture of nerves and steely resolve. Reporters lined the back benches, and a handful of tenants. Alan, the young couple, and 2 others took seats behind me, clutching their affidavits. Marcus Chen gave me a reassuring nod. Claire from the DA's office sat in civilian clothes, ready to observe. Across the aisle, Ms. Green sat flanked by her attorney, her posture rigid. The bailiff called the court to order, and the trial began. Marcus delivered his opening statement with precision. He painted a vivid picture of my discovery. Late-night confirmation emails, rerouted routing numbers, and a shell company deliberately incorporated to siphon rent. He outlined the emotional toll on tenants who feared eviction and faced financial ruin. Then he laid out our ask: restitution of all diverted funds totaling $14,400, representing the 12 months of misdirected rent at $1,200 each, statutory treble damages under the Landlord-Tenant statute, bringing the sum to $43,200, recovery of attorney fees, and punitive damages for fraud and harassment. The judge listened attentively, pen in hand. When Ms. Green's attorney gave his opening, he attempted to soften her image, portraying her as an overwhelmed property owner struggling to manage multiple buildings. He claimed any diversion of funds was an innocent bookkeeping error, that she had returned the October payment once notified, and that tenants had benefited from community repairs she had funded. His tone was conciliatory, but the tenants whispered among themselves, recalling the eviction addendum notices and threats that had followed. The first witness was me. I took the stand, heart-pounding, and delivered my testimony calmly. The timeline of payments, the discovery of mismatched routing numbers, the cease and desist letter, and the mounting intimidation tactics. I described the sleepless nights, the emotional distress of wondering if I'd be evicted, and the solidarity that blossomed among neighbors. Under cross-examination, Ms. Green's attorney tried to suggest I had coached tenants and exaggerated the harassment, but Claire later told me my honest recounting and sworn affidavits held firm against his objections. Next came Alan, my neighbor. He testified to the unjust rent hikes and late fee notices imposed only after he questioned the addendum. His affidavit corroborated my own, and he spoke passionately about the day he realized his deposit had disappeared into thin air. The judge asked a pointed question. "Mr. Allen, did you consult any outside group when you drafted your affidavit?" He shook his head. "No, Your Honor. I wrote what happened to me." His sincerity resonated in the hushed courtroom. The young couple took the stand next. The wife, voice trembling, recounted the moment she saw Ms. Green's red ink notice threatening eviction. The husband produced bank statements showing their security deposit vanishing from one account and reappearing in the shell company's ledger. They described the humiliation of feeling powerless in their first apartment. Their testimony underscored a pattern. Each tenant experienced a variation of the same scheme. After lunch, Marcus called a forensic accountant, Dr. Samuel Price, who had traced the flow of tenant funds across multiple corporate accounts. Dr. Price projected charts on the courtroom's video monitor, illustrating how $17,400 in total rent payments, including November and December, had traversed from Green Holdings LLC to E. Green Properties, despite only the former being the designated payee. He explained the hallmarks of deliberate concealment: identical mailing addresses but different routing numbers, successive name changes on deposit records, and false confirmation emails sent by a proprietary portal programmed to mask redirections. His expert opinion sealed the narrative of intentional fraud. In the late afternoon, Marcus called a representative from the Housing Authority, Ms. Janet Alvarez, to testify about the addendum notices and Ms. Green's unlicensed practices. Ms. Alvarez described how the landlord's rental license had lapsed in 2023 and that operating without a valid license exacerbated the severity of her violations. The Housing Authority was poised to revoke her license entirely, pending the final outcome of both civil and criminal proceedings. Finally, the DA's office joined the fray. Claire took the stand to summarize the criminal investigations underway. She could not speak to grand jury specifics, but she confirmed that the DA had gathered sufficient evidence for wire fraud and embezzlement charges related to the diverted rent. The threat of jail time loomed, reinforcing the civil case's gravity. As she spoke, I felt a surge of conviction. Our unified pursuit of justice had transcended mere restitution. Ms. Green's attorney mounted a last defense, questioning the admissibility of certain emails and challenging the credibility of tenant testimonies. But Marcus and the judge swiftly dismantled his objections, citing clear chains of custody for evidence and the notarized affidavits. As the defense rested, I realized how thoroughly we had documented every detail. The next morning, after brief closing arguments, the courtroom reconvened for the verdict. The judge's voice was measured as she delivered her findings. I find in favor of the plaintiff. The defendant engaged in a deliberate scheme to divert rent payments through an unauthorized account, violating both statutory and common law obligations. I award restitution of $14,400, trebled to $43,200, plus $6,800 in attorney fees and $10,000 in punitive damages for fraud and harassment. The injunction will be made permanent, and the court refers the matter to the Housing Authority to finalize license revocation. Appropriate notices shall issue forthwith. A murmur of relief rippled through the gallery. Marcus turned to me with a grin. Tenants wept quietly. Reporters scribbled furiously, capturing every word. I felt an overwhelming mix of vindication and gratitude. This victory belonged to every tenant who had dared to stand up. Weeks later, in a separate courtroom, Ms. Green faced the grand jury. The DA presented the same evidence we'd used in civil court: fraudulent routing numbers, shell companies, and harassing communications. She was indicted on multiple counts of wire fraud and embezzlement. In April, she pled guilty to 3 felony charges in exchange for a recommended sentence of 12 months of community service, $25,000 in fines, and restitution of an additional $5,000 in court costs. The state revoked her rental license permanently. By spring, tenants had recovered the diverted rents, and the punitive damages funded new community repairs, fresh paint in the lobby, upgraded laundry machines, and a small garden courtyard. The building felt renewed, not just structurally but in spirit. Our online group evolved into a tenant association that advised renters citywide on their rights, helping prevent similar schemes elsewhere. I moved a few blocks away into a new apartment, managed by a well-reviewed company with transparent billing practices. But I kept my Elm Street documents and the friendships forged during the ordeal. Each month, when I write my rent check, I still feel a quiet pride. The memory of my clickbait discovery, the fierce negotiations, and the solidarity that made justice possible. When I first stepped into that dusty Elm Street apartment, I never imagined I'd spark a movement. What began as a personal battle for my own rent payment evolved into a collective crusade against injustice. Looking back, the sweetest victory wasn't the money recovered or the punitive damages awarded. The rent-to-own racketeer lost everything, including her reputation, and we, the tenants, gained something far more lasting: